There it is. Welcome to The Reset. I am your host, Andre Clay. And on today's show, No Duty to Retreat, Karmelo Anthony's claim of self-defense. This episode of The Reset Talk Show is being live streamed on Facebook and on YouTube. Be sure to like, share, and subscribe to both platforms at facebook.com/The Reset and on our YouTube channel at The Reset Online. You can also show your support for all of our efforts here via Cash App, Venmo, or Zelle. The comments section is open for all to chime in on today's discussion. Phone lines will also be open later in today's broadcast. When that time comes, please give us a call at area code 815-905-1082. Again, that's 815-905-1082. All right, let's get this started. Now, when I took a look at Texas law for what qualifies one for a self-defense claim, there were two penal codes that I came across that I believe that attorney Mike Howard might use for his defense. The first of the Texas penal codes for self-defense under subchapter C, protection of persons, is subsection 9.31, self-defense, or simple self-defense, which reads, except as provided in subsection B, a person is justified in using force against another when and to the degree the actor, which would be Karmelo Anthony, reasonably believes that the force is immediately necessary to protect the actor against the other's use, which would be the Metcalf twins, use of or attempted use of unlawful force, which is the use of force that is not justified under the immediate circumstances, meaning it is not permitted by law. An example of this might be in Karmelo's statement in the arrest record, where he says, quote unquote, he put his hands on me, referring to Austin Metcalf. Now, the conditions for which the actor's belief that the force was immediately necessary, as described by this subsection, is presumed to be reasonable if the actor meets one of these qualifiers. Number one, knew or had reason to believe that the person against whom the force was used, which was Austin, A, unlawfully and with force, entered or was attempting to enter unlawfully and with force the actor's occupied habitation, vehicle, or place of business, or employment. Karmelo is a student and was captain of the track team and was on the track meet roster, so that was his business. He had business being there. Or B, unlawfully and with force removed or was attempting to remove unlawfully and with force the actor from the actor's habitation, vehicle, or place of business or employment. Or C, was committing or attempting to commit aggravated kidnapping, murder, sexual assault, aggravated sexual assault, robbery, or aggravated robbery. Now, some would argue that when the Metcalf twins attempted to physically remove Karmelo from the tent he was sitting under meets the legal definition of kidnapping, which is the taking of a person against his or her will or from the control of a parent or guardian from one place to another under circumstances in which the person so taken does not have freedom of movement, will, or decision through violence, force, threat, or intimidation. Reasonable force is also presumed if the actor, too, did not provoke the person against whom the force was used. Now, some would argue here that the mention in the arrest report by a witness to the incident that when Karmelo told Austin, quote unquote, touch me and see what happens, this might be considered provocation to some. But then to others, it's a clear warning, that Karmelo meant business when it came down to Austin, and he was willing to defend himself. And lastly, number 3, was not otherwise engaged in criminal activity other than in Class C misdemeanor. That is a violation of a law or an ordinance regulating traffic at the time that the force was used. So, when is the use of force not justified? Well, according to Penal Code 9.31, the use of force against another is not justified in 1, response to a verbal provocation alone, which didn't happen because according to what's in that arrest report and from what Hunter stated in those interviews, after he initiated confrontation with Karmelo verbally, his brother Austin had the physical confrontation with Karmelo. And number 2, to resist an arrest or search that the actor knows is being made by a peace officer or by a person acting in a peace officer's presence and at his direction, even though the arrest or search is unlawful, unless the resistance is justified under subsection C, if the actor consented to the exact force used or attempted by the other, which is called mutual combat. This did not happen here in this particular incident. Number 4, if the actor provoked the other's use or attempted use of unlawful force. When we come to the next penal code that I came across, Penal Code Section 9.32, deadly force in defense of person. Now, this states that a person is justified in using deadly force against another if 1, the actor, again, Karmelo, is justified in using the force against the other under Section 9.31. And now this means Karmelo had to first qualify under Section 9.31 before he could even use Section 9.32. Number 2, when and to the degree that the actor reasonably believes that the deadly force is immediately necessary. Examples of this can be when A, to protect the actor against the other's use of attempted use of unlawful deadly force, or B, to prevent the other's imminent commission of aggravated kidnapping, murder, sexual assault, aggravated sexual assault, robbery, or aggravated robbery. Number B, or letter B, the actor's belief that deadly force was immediately necessary as described or presumed to be reasonable if the actor 1, knew or had reason to believe that the person against whom the deadly force was used, A, unlawfully and with force, entered or was attempting to enter unlawfully and with force the actor's occupied habitation, vehicle, or place of business or employment, or B, unlawfully and with force, removed or was attempting to remove, unlawfully and with force, the actor from the actor's habitation, vehicle, or place of business or employment, or C, committing or attempting to commit an offense described by subsection A2, like did not provoke the person against whom the force was used, and 3, was not otherwise engaged in criminal activity, other than a Class C misdemeanor that is a violation of a law or ordinance regulating traffic at the time the force was used. Now, the last 2 subsections address the no duty to retreat provisions of the Texas self-defense law, which states, C, a person who has a right to be present at the location where the deadly force was used, who has not provoked the person against whom the deadly force is used, and is, or rather, who is not engaged in criminal activity at the time the deadly force is used, is not required to retreat from using deadly force as described by this section. D. For purposes of section A2, in determining whether an actor described by section C reasonably believed that the use of deadly force was necessary, a finder of fact, which would be the jury, may not consider whether the actor failed to retreat, which Karmelo had no duty to do so. Now, there was something else that I came across in researching Texas self-defense law, and it's called the multiple assailants doctrine. Now, the multiple assailants doctrine, it is a legal practice in self-defense law that recognizes the right to use force, including deadly force, when faced with a threat from multiple attackers. It essentially expands the scope of self-defense to include situations where a person is attacked by more than one person, even if those individuals directly involved in the initial assault. Remember, Hunter Metcalf, in the Fox News interviews, stated that when he and Austin and two other friends came to sit under their school canopy, they saw Karmelo already sitting there. And according to Hunter, after he initially confronted Karmelo for what he described speaking disrespectfully and telling him to leave, his brother Austin aggressively confronted Karmelo. His words. First, by grabbing and then throwing his backpack and then physically assaulting him. Now, the multiple assailants doctrine dates back to around 1884. Under this doctrine, if you're being attacked by multiple people at once, you are free to use self-defense against any of them if that person hasn't attacked you yet. Now, it started off as an application of the law of parties, which means an attack by one was an attack by all in the party, authorizing self-defense against everyone in the party. The next one, it is illustrated in the court case of Black versus State, which stemmed from a West Texas shootout in 1912. 4 men went into town aiming to kill Black and his friend Hamilton. The attackers took positions surrounding Black and Hamilton. After the firing became general, 3 of the attackers got shot. The Court of Criminal Appeals held that because the 4 were attacking as a group, Black and Hamilton could shoot any one of them, even without evidence that the particular target had opened fire. Now we're ready for the next scene. Another case in which this doctrine was applied was when a man named Jordan was leaving town, but he decided imprudently to go with his friends, Brian, and have a one last dinner at the Silver Star, which was a restaurant that his ex-girlfriend worked at. Her name was Varley. Now, when Jordan and Brian arrived, Varley was there with 4 male friends, Royal, Crumpton, Pritchard, and Stevenson. After the predictable drama ensued inside the restaurant, Jordan and Brian decided to leave. Now, when they did, Varley and her friends were outside. There were words, and when Royal knocked Brian out with a single punch, Jordan testified that after he heard Royal punch Brian, he ran to his car. Ryan and Stevenson chased him, and Royal caught him by grabbing his face from behind. Now, Jordan pulled a pistol from his pocket and fired 3 times without aiming. 1 round hit Royal, 1 hit Varley, and 1 hit a parked car. Jordan was charged with aggravated assault for shooting Royale and with felony deadly conduct for shooting in the direction of Varley and Crumpton. For both offenses, the jury was instructed to acquit if Jordan acted in self-defense based on a reasonable fear of deadly force. Sorry, let me go back. On the multiple assailants doctrine, though, the defense requested the jury instructions authorize self-defense if Jordan feared deadly force from Royal or others with him. This request was initially denied. The jury hung the aggravated assault charge, but convicted on the deadly conduct. On appeal from the conviction, Jordan raised 4 complaints about the self-defense instruction, including the lack of the phrase, quote, or others with him. The Sixth Court rejected all of these complaints by holding that Jordan was not entitled to a self-defense instruction at all. This was so the Sixth Court held because there was no evidence Jordan believed that Varley and Crumpton were attacking him. Because Jordan was not entitled to a self-defense instruction, any errors in that instruction were harmless. The Court of Criminal Appeals granted review. In an opinion written by Judge Keel and joined by 5 other judges, that court reversed. Whereas the Sixth Court has seen the case as a question of whether Jordan's testimony and justified the use of force against Varley and Crumpton, the Court of Criminal Appeals saw it as a question of whether Jordan was justified in shooting any member of the mob. The court described Jordan's testimony as being that he fired because he felt he had no other choice. The court said this testimony would have allowed a jury to conclude he reasonably believed deadly force was necessary to, quote-unquote, protect himself from the group's use of deadly force. Citing Black, the court noted that it did not matter whether Varley or Crumpton had attacked Jordan yet. What mattered was whether Jordan had, quote-unquote, had reasonable apprehension of actual or apparent danger from a group of assailants that included Crumpton and Varley. This put me in the mind of Karmelo Anthony, who again, as stated in the arrest report, was assaulted by Austin Metcalf and whom, according to Hunter, in those Fox News interviews, had come to his aid after initiating the confrontation which resulted in the stabbing of Austin. Now, recently, there was a case that many believe sets a precedent for a possible acquittal or a lesser charge for Karmelo Anthony. That is in the case of Kason Allison, 17, who in 2022 was accused of stabbing to death fellow student Joe Ramirez, also 17, inside a Belton High School bathroom, which is about 2 hours away from Frisco, where the Anthony incident took place. Now, in this case, Allison, whom initially agreed to fight Ramirez off school grounds, ended up fighting him in the boys' bathroom during school hours. Allison stabbed Ramirez at least 4 times, and I want to say it was 17 according to the autopsy report. But instead of fighting, or rather after the fight, Allison ran home. Ramirez, however, he died after collapsing in the school hallway, according to court testimony and school camera footage. Allison was arrested at home after initially received a $1 million bond, kind of like what Anthony had. It was soon reduced to $175,000. Kason had been home on house arrest people since posting bond back then. But then finally, on Tuesday, April 29th, 2025, a jury found Kason Allison guilty of criminal negligent homicide. Now, this right here only carries a sentence of from 6 months to 2 years in the state prison. And probation in this case may be applicable because of the time served under house arrest for the last 2 years. Now, many argue that the stabbing of Ramirez was premeditated by Allison, hence the numerous stab wounds he inflicted on him. And despite his supposed reluctance to fight him, he tried to acquire a firearm the day before the fight, according to witnesses in court. Now, when we contrast and compare these two cases, I can see why so many believe that Karmelo might have a chance at being acquitted. So what say you? How are your feelings about all of this? What do you think can possibly lead that pathway towards an acquittal for Karmelo Anthony? Do you agree that his attorney has those penal codes in Karmelo's favor? Do you not believe that? Because we do recognize a lot of the challenges that his attorney is going to be facing. He'll have to face asserting a self-defense claim, particularly concerning the legality of Karmelo's actions and the context of the incident. His attorney's key challenge will be in demonstrating for a jury now that Karmelo's use of force was necessary to prevent imminent physical injury or death at the hands of the Metcalf twins, and that it was reasonable to do so. District Attorney of Texas, Greg Willis, said that the case against Anthony could go to a grand jury by the end of June, which would then decide whether he should face trial. There is no specific court date available yet, as the case is still early in the stages of its investigation. Again, what say you? Please feel free to give us a call, 815-905-1082, 815-905-1082. Other than that, I want to thank you all for chiming in. Enjoy the rest of your evening. Peace.